Thank you very much for joining us in this session on distribution and the humanitarian development peace nexus. On this panel, we'll hear about 3 fascinating papers which look at the roles of international law in shaping different decisions and practices of distribution in conflict and post-conflict settings. This panel is organized in cooperation with the Endless Conflicts Project, hosted at the University of Glasgow in partnership with the Freie University in Berlin. And as you will notice, there are a lot of synergies between the focus of the project on the issues of peace, humanitarian, and development in situations of protracted conflict, and the papers that we'll hear about today. Just to go through, I'm sure you're all familiar with the format by now, but I'll just go through the basics quickly. Each presenter will have 15 minutes, and I'll remind you when you have 2 minutes left. After the presentations, we'll have a Q&A session. For that, you can either submit your questions in writing via the chat function, or simply raise your virtual hand, which you can find under the Reactions tab on the bottom of your Zoom screen. And then you can ask your questions. Please feel free to submit your questions via the chat functions throughout the presentations without necessarily having to wait till the end. Our first speaker on the panel is Eliana Cusato. She's a Marie Curie postdoctoral fellow at the Amsterdam Centre for International Law. Prior to this, she was a lecturer at Essex. She holds a PhD from the National University of Singapore and serves as a member of the editorial board of the Asian Journal of International Law. Her monograph, The Ecology of War and Peace, is forthcoming later this year with Cambridge University Press. Eliana is going to talk about global extractivism and the politics of conflict mineral regulation. Over to you, Eliana.
Thank you. Thank you very much. Hello, everyone. Let me share my screen with you. Yes, I hope that worked. So thank you, Asli and Gigi, and to organizer of this conference. I am truly delighted for the opportunity to present my paper today here. So the aim of this paper is to critically reflect on the distributional impact of global regulation of conflict mineral. And those are minerals like copper, gold, tin that are extracted in conflict zone. And in doing so, this paper intends to contribute to ongoing debates on the relationship between international law and political economy by making visible how the logics of the market penetrate legal structures, reproducing patterns of exploitation and dispossession. So just a little bit of background. Since the late 1990s, there's been a proliferation of transnational regulatory initiatives addressing the interplay between resource extraction, violent conflict, and human rights abuses. Probably the most well-known instrument is the Kimberley Process certification for diamonds. So in response to civil society campaigns against blood diamonds, the Kimberley Process was established to regulate the legitimate trade in diamonds and exclude conflict diamonds from it. So other instruments to which I will refer in my presentation include the Extractive Industry Transparency Initiative, OET, and the OECD due diligence guidance for responsible supply chains of mineral from conflict and high-risk areas. So while these norms originate in the international or transnational sphere, they also had a strong influence upon national and regional laws. So you can think about, for instance, Section 1502 of the US Dodd-Frank Act on conflict mineral from the DSC, or you can think about the European Union Regulation 821, which entered into force in January this year, laying down supply chain due diligence obligation for companies importing certain minerals from conflict areas. So the development of international and transnational regime for the governance of conflict mineral is obviously part of a broader trend. Since the end of the Cold War, a wide range of issues that formerly understood to be political and within the control of states have been reframed as matter of economic governance and therefore moved away from the purview of the state. At the core of this process lies the development of alliance between state and corporate authorities and the progressive expansion of private regulatory power. So it's not a mystery that many of the transnational norms that I will discuss have been generated through process driven by or shaped by the industry, and which is increasingly seen as a producer of regulation. So the shift from a domestic to globalized regime of conflict mineral resource governance has been facilitated by the circulation of two assumptions about conflict minerals. So the first is the idea that illegal resource exploitation represents a threat to international peace and security. So based on a variety of theories, such as the resource curse, governance bodies like the United Nations Security Council have adopted measures restricting trade in certain commodities, primarily sanctions. So by curbing illegal trade by rebel and terrorist groups, the goal of this economic measure has been to pacify conflicts and to reinforce political stability. The establishment of the control by the legitimate government over its territory is, in other words, instrumental to ensure a disciplined extraction of mineral. And the second is the argument that weak and conflict countries, and those are primarily countries in the global south, need to improve how natural resources are managed in order to avoid further conflict. And to that end, they're called to subscribe to regulatory instruments mentioned before, such as the Kimberley process or the AT, which promote a set of liberal values such as transparency, accountability, and good governance. So, but how do transparency, accountability, and good governance help prevent conflict? So of course, these concepts are deliberately open-ended and mean different things to different people, and there is no perhaps a right answer to this question. But one powerful claim, which I think is quite important to understand the distributional effects of this instrument, is that transparency and accountability facilitate post-conflict recovery by incentivizing foreign investment, which in turn generates state revenues and peace dividends. So this is based on the presumption, valid in peace and in war times, that minerals are essential for modern living and that can provide a pathway to poverty alleviation and economic development. So in this context, the mineral extraction, if conducted in line with these international transnational norms, becomes a crucial element in supporting the transition from conflict to peace. And this is precisely the claim that my paper aims to challenge. So because of the limited time, I will try to unpack my argument by focusing on three reasons why I think this regulatory instrument failed to achieve this goal, and rather they reproduce patterns of resource dispossession. And of course, I'm happy to elaborate more on these points in the Q&A session. So the first point, as mentioned before, is that in a globalized society, the private sector is increasingly seen as assigned roles conventionally attributed to state that contribute towards the realization of public goods. So in conflict setting, this reconfiguration of the relationship between public and private authorities, and here I'm specifically talking about extractive industries, gives rise to a paradox. So while extractive corporations might have contributed to conflict and abuses, in the post-conflict phase, they are framed as partner or engines for peace. And the following statement made by the think tank Swiss Peace, I think, is quite revealing. So my argument is that the law contributes to the representation of the private sector as an engine to growth and resource of welfare gain in fragile and conflict countries. So for instance, if you consider the introduction to the OECD due diligence guidance, it is said that, and here I'm quoting, in conflict affected and high risk areas, companies involved in mining and trading minerals have the potential to generate income, growth, and prosperity, sustain livelihoods, and foster local development. So that is not to say that this regulatory instrument fails to acknowledge that the complicity of transnational companies in conflict and human rights abuses. Indeed, the AT and the OECD due diligence guidance move precisely from the finding that transnational corporations may contribute to adverse impacts. But their purpose is precisely to address corporate violation. But by doing so, they also operate a metamorphosis in how the extractive industry is viewed in the transition from conflict to peace. So this regulatory framework presents themselves as the tool to transform the risk of mineral extraction in conflict countries into opportunity for investment and economic growth in the post-war environment. So framing the corporation as a partner for peace legitimizes a set of principles and rules aimed at increasing the capacity of the corporation to operate in countries emerging from conflict. So for instance, rules protecting foreign investment and private property become an important element in the transition from conflict to peace. So one of the problems, as put by critical development scholars, is that the emphasis on marketization of natural resources and export-driven growth may sideline and even reproduce some of the inequalities important to conflict causation. So the second point is that while these legal regulatory arrangements are often justified by the desire to mitigate human rights abuses associated with extractive activities, they often uphold a minimalist conception of human rights that ignores distributive concerns. Of course, it will be impossible to engage with a critique of contemporary human rights approaches for their insufficient attention to question of global redistribution. There is, of course, a rich scholarship, and I put some reference in this slide, calling attention to the interrelationship of human rights, neoliberalism, and globalized economy, which helps make sense of the scarce attention that standards regulating conflict mineral pay to the structural economic condition paving the way for conflict. On the contrary, you can see on the left side of the slide, the official narrative on conflict minerals tend to focus on highly visible atrocities perpetrated by state and military actors against the bodies of the victims. So the OECD due diligence guidance, for instance, outlined the following forms of serious abuses: torture, cruel, inhuman, and degrading treatment, worst form of child labor, gross human rights violations, such as widespread sexual violence, war crimes, crimes against humanity, genocide. Of course, I mean, these are serious abuses, but by focusing on the pure suffering of victims, the OECD guidance reinforced the idea that violations of human rights have nothing to do with historical legacies and systemic dynamics of economic exploitation. So the minimalist conception of human rights in norms addressing conflict mineral comes at the expenses of more emancipatory engagement with the violence associated with extraction of natural resources. And here we can refer to the concept of structural violence, for instance. So by turning a blind eye to collective demands for more equitable resource distribution, contemporary approaches leave unchallenged and might even legitimize resource dispossession. The third point I want to make is, as mentioned before, one of the objectives of this regulatory instrument is to establish good governance over mineral as a way to reinforce the peace process. So while, of course, I cannot fully engage with the critique of the concept of good governance, it's important to note that some post-colonial scholars, such as Anthony Anghie and James Tuogati, have showed how the discourse of good governance has been developed primarily in relation to the Global South, based on the idea that a lack of development is attributed to the absence of good governance. And this discourse frames bad governance often as a local dysfunction, which arises from factors that are endogenous to the Global South. So the emphasis on the local and its limitation, I think, can be best illuminated by looking at, for instance, how corruption in extractive industry is framed and addressed. So, of course, corruption is a big problem which deprives developing countries of money necessary for development and poverty alleviation. But while corruption happens at any stage of the global supply chain of mineral, it's telling that rules prescribing it focus on the place of origins of natural resources. So legal efforts to fight corruption include, for instance, the 2003 UN Convention Against Corruption. So this instrument requires states, party to implement measures to address criminal offenses committed within their territory. This is where the encounter between the corrupter and the corrupted take place. And of course, this assumes that corrupt practice can be localized and fought by changing the legal landscape in corrupt countries. But as other scholars have pointed out, such approach to the problem, such approach is particularly problematic if we think about grand corruption, which is corruption, abuse of power that happens at the higher level. So here, the idea that corruption is captured by the relationship between the corrupter, often a national of a wealthy nation, and the corruptible public official of a developing country is open to contention. So while the state, principally the host state, is blamed for corrupt resource governance, transnational corporate power remains insulated from scrutiny. And this approach, I think, has important distributive consequences as it leaves unchallenged the structural causes of bad governance in the Global South and may perpetuate grievances over resource access, which may later feed into conflict. So in conclusion, to wrap up this short presentation, sought to examine the role of legal norms in facilitating the reproduction of extractivist model of development in countries emerging from conflict. It raised questions about the political and economic interest underpinning the existing regulation of conflict mineral. And moving forward, more research is needed to illuminate how the reconfiguration of public and private spheres in the transition from conflict to peace becomes instrumental to obscure corporate power and insulate private actors from scrutiny. So thank you very much, and I look forward to your questions.
Thank you very much, Eliana, for this insightful presentation and also for sticking to the time limit. The next presenter is Daniëlla Dam-de Jong. I do apologize if I'm pronouncing any of these names wrong. Daniëlla is an associate professor at the Grotius Centre for International Legal Studies at Leiden University. Sorry. Florian, could you please mute yourself? Or Eloise, are you able to do that? Thank you so much. Daniëlla is an associate professor at the Grotius Centre for International Legal Studies at Leiden University. She's written and advised extensively on international legal aspects of natural resource governance, with a focus on interconnections with international peace and security. Her monograph, International Law and Governance of Natural Resources in Conflict and Post-Conflict Situations, which was published in 2015 with Cambridge University Press, has received a research prize by the foundation Premium Erasmianum, I hope. Daniëlla, over to you.
Thank you very much, Asli, for this kind introduction, and also thank you to the organizers for giving me the opportunity to present my work here. If sometimes you hear screams, that is because my husband and my son are playing a very capitalist game called Monopoly, and the screams are there for excitement. So my presentation today zooms in on distributional challenges related to land use as part of peace processes. According to a major study conducted by UNEP and partners, land issues played a major role in all but 3 of the more than 30 intrastate conflicts that took place between 1990 and 2009. So based on this observation, one could argue that addressing land issues in peace processes is essential for the resolution of these conflicts. This, however, comes with a number of distributional challenges that stem from conflicts between and within peacebuilding priorities. And these priorities often involve a difficult balancing of interests, which all too easily leads to renewed tensions and a relapse into armed conflict. So the objective of this presentation is to shed light on the impact of international law on such distributional challenges in peace processes. For this purpose, I will first present the main priorities faced by post-conflict countries related to land use and distribution, drawing on examples of peace processes to see how questions of land use and distributions have been conceptualized therein. And I will subsequently zoom in on the draft general comment on land that was recently published by the Committee on Economic, Social and Cultural Rights as a way to help mainstreaming international legal responses to distributional challenges related to land. So looking first at the peace building priorities related to post-conflict land use and distribution, I will discuss in turn the question of land distribution and return of dispossessed land, the restoration of land damaged by armed conflict, and lastly, the function that land performs in economic reconstruction. So turning first to land distribution or redistribution and return of dispossessed land. The majority of post-conflict states are developing countries that are highly dependent on agricultural commodities, not only as export commodities, but first and foremost to support the livelihood of their populations. Addressing disputes over access to arable land and over the dispossession of land, either by past political regimes or as a consequence of the armed conflict, is therefore a vital aspect of the peace-building process. This is reflected in peace agreements that aim at rebuilding society after an armed conflict. Questions regarding land tenure are often central to these agreements, many of which aim to address past injustices with respect to inequalities in land tenure and dispossession of land. In these agreements, questions of land redistribution are often addressed by establishing institutions responsible for developing policies with respect to land distribution and settling disputes relating to property rights. Examples of agreements establishing such institutions include the 1996 Guatemalan Agreement on Social and Economic Aspects of the Agrarian Situation and the 2016 Final Agreement for Colombia. Such institutions often have wide-ranging mandates consisting of promoting access to land ownership for vulnerable groups as a means to reduce inequalities, to return land to dispossessed persons, including indigenous peoples, and to allocate lands to former combatants as a means to reintegrate them into society. These objectives are not necessarily mutually supportive and must be carefully balanced to avoid tensions, for instance, between displaced persons reclaiming their land and other communities and individuals who have settled here in the meantime. Turning now to the second peace-building priority, which is restoring degraded lands, we can say that armed conflicts can have serious impacts on the environment and thereby also affect the productivity of land and related ecosystems. So it has been reported that over 90% of the major armed conflicts between 1950 and 2000 occurred within countries containing biodiversity hotspots, and more than 80% took place directly within hotspot areas. So these figures are indicative of the potential for damage to parts of the environments that are of prime importance for nature conservation. Such damage may have occurred firstly as a consequence of hostilities, for example, through landmines, toxic remnants of war. Second, through unsustainable practices relating to illegal exploitation of natural resources by armed groups, as also commented on by Eliana. And thirdly, as a consequence of internal displacement as a result of armed conflict. So the post-conflict phase offers novel opportunities to reinstate previous protection regimes over these areas, but also to designate new conservation areas. The 2016 Colombian Agreement again offers a good example of this, as it seeks to establish protected areas of special environmental interest, which are further specified in the agreement. Usually, however, peace agreements are silent on the types of measures that are needed for nature conservation and refer more generally to environmental conservation. The effects of armed conflict on land may also affect peace-building processes in other ways, as degraded land is not suitable for agriculture and other livelihood purposes. Environmental conservation measures may be essential to safeguard the quality of the land, for instance, for the purpose of preventing soil erosion and desertification. This is exemplified by the Arusha Peace and Reconciliation Agreement for Burundi, which determines that, and I quote, "The policy of distribution or allocation of new lands shall take account of the need for environmental protection and management of the country's water system through protection of forests," end of quote. This example clearly shows the interconnections between land as a productive resource and environmental protection. Turning now to the third and final peace building priority, which is kickstarting the economy through foreign investment in agriculture and the extractive industry. Natural resources, such as minerals, oil, gas, and timber, but also land itself, are strongly associated with the delivery of peace dividends, whether this is something that can be accepted or not, but this is notably in policy language. And so these peace dividends consist notably of basic services and the creation of jobs. And the idea is that these help foster, and I quote again, social cohesion and stability, build trust in the peace process, and support the states to earn legitimacy under challenging conditions, end of quote. Attracting foreign direct investment is considered one of the key means to help the state in delivering such peace dividends, but it can also undermine them, as foreign direct investment can further exacerbate tensions when the negative externalities, such as competition with local communities over water or land, or environmental pollution, cannot be offset by its positive effects. And this is an issue in several peace processes. Again, post-conflict Colombia provides an example where the prospect of generating peace dividends in combination with improved access to regions that were previously controlled by the FARC has proven an incentive for the governments to grant concessions for the exploitation of gold without adequately taking into consideration the broader implications for the peace process. Post-conflict Cambodia provides another example of a state in which investment has increased tensions over access to lands, notably because of state-sanctioned land grabbing fed by endemic corruption and elite structures. To summarize, I just discussed the main peace-building priorities related to land, namely land redistribution and return of land, the restoration of land damaged by armed conflicts, and the function that land performs in economic reconstruction. Distributional challenges exist both between and within these priorities. So I will now turn to the impact of international law on addressing these distributional challenges. And I will do so by focusing on the new general comment on land, because I argue that this general comment has the potential to help mainstreaming international law approaches by offering a distinct lens for addressing distributional challenges, which is based on the dignity of the human person. So turning to this general comment on land, which is still in draft form and has published only a couple of weeks ago, this comment clarifies the interrelations between access to land on the one hand and the realization of rights protected by the International Covenant on Economic, Social, and Cultural Rights on the other. Most notably, the rights to adequate food, water, and housing as part of the right to an adequate standard of living, protected by Article 11 of the Covenants, and the right to health pursuant to Article 12 of the Covenants. It designates access to land as, and I quote, an important precondition, end of quote, for the realization of these rights. Furthermore, it connects access to land as a precondition for the realization of covenant rights with environmental protection, by noting that land is, and I quote, a fundamental component of ecosystems. Land use should be sustainable in order to maintain the long-term social, economic, and environmental functions that land provides to human beings. Consequently, the committee also recognizes and emphasizes the importance of ecological concerns when it comes to land, including the preservation of biodiversity, as well as conservation, preservation, protection, and restoration of lands to maintain its agroecological services, end of quote. Looking more closely to the obligations of states pursuant to the International Covenant on Economic and Social Rights, the committee provides guidance on how states' obligations to respect to protect and to fulfill human rights take shape in the context of land. Very importantly, the committee not only provides guidance to states with respect to how they should understand their obligations with respect to land in their own territory, but also looks at the extraterritorial obligations of states. Relevant obligations for states with respect to land within their own territory include the obligation to respect existing access to land of all legitimate tenure right holders without discrimination, to protect individuals and communities against infringement of their tenure rights and access to land by third parties, which of course includes investors, and to facilitate secure, equitable, and sustainable access to use of and control over land for those who are landless or live in poverty. The general comment, furthermore, contains guidance for states with respect to conditions for land administration, for the relocation of persons, and in a specific section on conflict and post-conflict situations, on the rights of displaced persons, which are helpful in relation to land reform programs in post-conflict states. It also contains recommendations for states to prevent that large-scale land investments infringe on the rights of local communities, such as introducing ceilings on permissible land transactions and democratic oversight of land transfers. When it comes to the question of compensation for expropriation of property rights in relation to land reform, the committee takes a bold position by stating that, and I quote, "While in general the compensation should be reasonable and relate to the market value of the acquired property, there are certain circumstances in which public interest may require less than market value compensation or exceptionally none at all." End of quote. This statement will surely lead to heated debates regarding the protection of foreign investors. At the same time, and this is a crucial contribution of the general comment, this statement can be connected to the obligations of other states with respect to realizing the covenant rights. The committee notes in this respect that, and I quote, "Extraterritorial obligations are of particular significance to the implementation of covenant obligations related to land. Land transfers are quite often financed or fostered by international actors, be it public or private investors," end of quote. Pursuant to the extraterritorial obligation to respect, states must, and I quote, "refrain from actions that interfere directly or indirectly with the enjoyment of the covenant rights in land-related contexts outside their territories, and to take concrete measures to prevent their domestic and international policies and actions from interfering directly or indirectly with the enjoyment of human rights," end of quote. While the obligation to protect, and I quote, "require state parties to establish the necessary regulatory mechanisms to ensure that business entities and other non-state actors that they are in a position to regulate do not impair the enjoyment of covenant rights in land-related contexts in other countries, including in the context of land acquisitions and other business activities which impact on the enjoyment of access to productive resources, including land," end of quote. These obligations translate inter alia in requiring transnational corporations to exercise due diligence, a development that is increasingly embedded in regulatory mechanisms, including in domestic legislation. To conclude this presentation, Asli, I argue that the general comment is particularly helpful for mainstreaming otherwise disparate international law approaches. It is, in my view, helpful in three respects. First, it is helpful because it confirms the interrelationship between human rights and environmental protection, and thereby consolidates broader developments towards realizing the potential of human rights law and international environmental law as mutually supportive regimes. Second, it provides guidance to states with respect to addressing access to land as a precondition for the realization of the covenant rights, and in this way may help post-conflict states in addressing tensions between peace-building priorities. Third, it is helpful by conceptualizing the realization of human rights as a shared responsibility for domestic and third states. In this way, it provides impetus for and consolidates trends with respect to mandatory due diligence for transnational corporations, and addresses in this way one of the most difficult challenges for post-conflict states with respect to land reform programs as a means to reduce tensions and foster a sustainable peace, while at the same time also offsetting some of the problems associated with corruption in transnational regimes. Thank you very much for your attention.
Thank you very much, Daniëlla, for this very comprehensive analysis of land reform in peace processes. With the third paper, we are going to take a step back from the post-conflict phase, as Aakriti is going to talk about humanitarian aid. She adopts a gendered lens to the analysis of humanitarian aid in her paper. Aakriti is an assistant professor and assistant dean at the Jindal Global Law School at Jindal University in India. She's written widely on the laws of armed conflict, gender, constitutional law, and human rights issues, and she's worked with Supreme Court and High Court lawyers in India. She holds master's degrees from Oxford and Leiden. Over to you, Aakriti.
Good afternoon, everyone. My name is Aakriti. I would like to thank everyone for giving me this opportunity to present my research. As Asli already mentioned, it pertains to humanitarian aid and looking at it from a gendered lens. So had this been like an offline forum, I'd probably start over a few questions for the audience to get their opinion on different points. But I'll still put those questions out there and maybe we'll get back to them as the presentation progresses. So the first very basic question that we can start off with is there a universal definition of women? Because once we start off with this question, we'll come to the understanding of how it's very difficult to define women, to put them in one box, because especially when you look at this question from an intersectional angle, you'll realize that the very definition of women is not a homogeneous category, it can take a heterogeneous form. And of course, it will depend on, say, the ethnicity, the race, the class, the gender identity, the sexual orientation, those kinds of multifaceted things which influence how we would go about defining women to begin with. So this brings me to my first limitation, and that would be that I would be restricting myself to heterosexual, female assigned at birth women only, and not going into the LGBTQIA or, for that matter, transgender women. I mean, so I'm not going into those questions. The second facet that is a limitation that I would want to bring forth in the very onset is that I would be restricting myself to the traditional role of women in an armed conflict and not going into the new required role of women of, say, being female combatants, for that matter. The third facet, the third limitation is that I am not going into natural calamities or other kind of emergency situations, and I'm only restricting myself to armed conflict situations. So the first question, of course, was that there is no universal definition of women. The second question was that do men and women have different needs? Now, of course, there is a commonality. There are some fronts where men and women do have similar needs, but there are, of course, fronts on which they differ. Especially when you look at education, when you look at something as simple as sanitization, some utilities in that sense, the needs of men and women would also differ. So just building on, the third point being, does an armed conflict impact men and women differently? Now, these are questions that we will be answering through this presentation itself. And the last thing, do you think interests of women will be better represented if there are more women on the decision-making panel? It's a little controversial, but that will be like my main argument towards the end. So I would start off by talking about armed conflicts. I'll be talking about how armed conflicts impact men and women differently. I'll be restricting myself to the binary understanding of gender. The second facet I'll be talking about is humanitarian aid and looking at it from a formal equality and a substantive equality approach. And lastly, since we would be adopting, we would already have an understanding on how men and women have different needs, how then their humanitarian aid requirements might also differ. How should we go about addressing this? Who should be calling the shots? How should the panel be representative of the different genders, and so on and so forth? So I'll start off with an armed conflict. Now, of course, we have a basic understanding, because there are different definitions of when an armed conflict begins and armed conflict ends. You have the first shot principle, you have the cessation of gunfire, and that's a very basic way of how you'd want to define armed conflict. But again, if you look at a normal situation, if you want to understand how the gender roles are, you would see what the situation or what the position of women are before the armed conflict. What is her position during the armed conflict, and what is her position post an armed conflict? That in itself transcends a very basic definition of armed conflicts. Now, for instance, if you look at, I'll take a case study. I'll take a case study of Yemen at this point. If you look at Yemen, and if you see the pre-conflict situation over there, you can see how, especially in context of, say, education, if you look at the urban areas and if you look at the rural areas, you can clearly see how men and women might not have equal access. Men and women might not even have the same kind of mobility. For instance, women would always require a man to escort him from one place to another, and that in itself would limit her on certain fronts. The other facet being that comes to employability. Now, of course, I told you about mobility impacting employability, then would be that it would be difficult for women to go back and forth from her workspace itself. It further gets restricted, say, if the area where she is working falls within an Islamic state, or whether it is governed by the government itself. So those are the kind of questions that then have an impact. Like other questions could be sexual and gender-based violence, which is of course very crucial and would be very crucial to today's presentation as well, because when you talk in context of sexual and gender-based violence, if it is already prevalent prior to the conflict itself, during the conflict too, it transcends and it reaches a very different level, because not only is sexual and gender-based violence looked upon as a weapon of war, but even if you look at sex and gender-based violence in a domestic scenario, since there is a change in gender roles, since there is a threat to the masculine image that the husband, for instance, has to live up to, that in itself can lead to an alleviation of sex and gender-based violence. And then, of course, post-conflict also, something as simple as having small arms still very much in the vicinity of the people in the households can act as a trigger towards increase in sex and gender-based violence. So, of course, if you look at all these facets are very crucial for understanding how a particular armed conflict situation then can impact women. And another very crucial factor would be the decision-making power of a woman. So, for instance, if pre-conflict, if you're talking about Yemen, the woman would have a very limited say on how something as simple as the finance of the household should be taken care of, the economics of the household should be taken care of, what kind of food needs to be brought forth, what kind of education should be provided to the children, things like that. And having a say in those very basics in a pre-conflict situation can have a long-term impact, because especially when you looked at Yemen and you looked at armed conflicts then, while the armed conflict was very much in place, there was also a change in gender roles. There was a change in gender roles in the sense that since men were being unemployed, men were restricted to the households, men were carrying on duties pertaining to the household, and women were the ones who were actually going out and who were actually working, then you can see there's a power imbalance, because the original power balance which is there, that the man would have a say in all the things, kind of changes, because the woman then is the breadwinner of the family. And if she's the breadwinner of the family, does she get to call the shots on how the finance of the house should be taken care of? So you can see how then an armed conflict situation, which has certain parameters which are very much prevalent prior, to the armed conflict itself can also change as the armed conflict progresses and actually can retain even post an armed conflict situation. Of course, there is a question on how far the woman is able to carry on such roles and whether she's not able to carry on such roles post an armed conflict too. But if you go by the age-old notion of how there is a direct impact on men, how men are targeted, they're killed, they're amputated during an armed conflict situation itself. Like the traditional military-aged man is the one who would be killed, even for drone strikes for that matter, are facets that would actually change who would be the breadwinner or the head of the household post a conflict situation. And if the breadwinner of the household or the head of the household is then a woman in a post-conflict situation, that in itself would change the dynamics of the society itself. Now, if there are triggers that stop her, like if there are still triggers like mobility, employability, education, wash facilities that restrict her, then that would work against her and in general would work against her, work against the society itself. Not going into the peace building dimension of it right now, but of course, peace building, again, women would have a very important role because if you look at Rwanda, if you look at Afghanistan, even now, during the peace talks, you don't have enough women representation. Even post the genocide in Rwanda, you had a greater population of women itself, which means they should have had a greater say. So things like that in itself would push for having more women representation in peace building processes. But since we want to go into humanitarian aid, I'd stop there for peace building. So just to give you a little bit of an idea of how an armed conflict can have a different impact on both the genders, whether it's men or whether it is women, and how the roles can be reversed, how women can be more empowered, and how far their position prior to an armed conflict can actually tell how far post an armed conflict her say in the society will be more. Now, if you look at humanitarian aid, and there is a very basic understanding of what humanitarian aid is. A humanitarian aid is to provide an emergency relief. So humanitarian aid can take different forms. It can be, for instance, health and medical assistance that can be provided for. It can be capacity building and training that can be provided for, or emergency food and shelter. And of course, humanitarian aid nowadays also can take the form of cash instead of getting food in kind. So, so when you look at humanitarian aid, of course, the first approach should be formal equality. The formal equality would be that everyone should be treated equally. Everyone should be equally eligible to get humanitarian aid. Now, we all know there are certain pitfalls to formal equality itself, and those pitfalls can be something as simple as that in the guise of equality, at times you actually end up doing more harm to a vulnerable group than you wanted. So that could also be the case in case of humanitarian aid, especially like, for instance, if you look at if aid is being provided on the basis of property, let's assume, and women are not allowed to hold property for that matter, because it's only the men who are allowed to have property in the society. So that in itself would work against her. But that's an extreme example. It doesn't happen in real life, but just to give a little more clarity on this point. So if you take humanitarian aid from a formal equality point of view, of course, everyone needs to be treated equally. But when you look at humanitarian aid from a substantive equality point of view, not going into a very strict form of cultural feminism over here, but still just looking at substantive equality and ensuring that you're accommodating the differences, also ensuring that you're also taking into account that probably women are affected differently from armed conflicts itself, and you're taking that into account and ensuring that her needs are also met. So for instance, something as simple as wash facilities during or post an armed conflict is crucial to ensure that women are not in a vulnerable section, women are not further victims of sexual and gender-based violence, because if you don't even have electricity on the path that leads to the latrines or the toilets, or you don't have a lock to those latrines and toilets, that in itself can make her more vulnerable in this scenario of an armed conflict situation or post an armed conflict situation. So bearing that in mind, substantive equality then can take such facets also into account to ensure that women's needs are taken care of, because of course we just established that in an armed conflict situation that they are affected differently. Which brings me to the last aspect of the presentation. Sorry, I rushed a little all throughout. And that deals with the decision-making part. Now, in the beginning, I spoke to you about how when you talk about decision-making, especially if we talk about what kind of say do women have when it comes to decision-making itself, which is prior to a conflict, during a conflict, post a conflict. So that should also be borne in mind, especially if you look at decision-making. There can be two ways of going about it. One is that you have more women at the local level. For instance, if there are women refugees or internally displaced women, you allow such women to be able to share their point of view, to be able to share their own concerns and bring it forth. Or the other way in which there can be more women representation could be at the higher level. And that is the decision-making authority who finally calls the shots on how to go about distributing humanitarian aid. So the only concern is that if you look at it from the local level, if the refugee women wants to bring forth her concerns about humanitarian aid and how these are the needs that she feels need to be addressed, then how far does her say is taken into account when it comes to making any sort of a decision? That is one point of view. And the other is if the women is represented in the decision-making panel itself, the very fact that she is represented, is that enough to ensure that women's concerns are addressed, or there's something more that needs to be done? And just one last point before I end, and that's something I want to draw from a paper that I've written about Commission of Inquiry and Sexual and Gender-Based Violence. And that is that, of course, it helps to have more women in the panel, because it's more like justice not only done, but it's also seen to be done. So the moment you see someone from your own side represented on a panel, you feel that it will, of course, take into account your concerns as well. But at the same time, there's also a need for a sense of gender sensitization, because the fact that you're belonging to a panel does not mean you'll be able to address all the concerns of someone who is on a local level. And that brings us back to the very first question that I came up with, and that is there a universal definition of women? Because even if there are more women on the decision-making panel, are they just going to present concerns from their vantage point, or also take into consideration the intersectional angle of how a refugee woman would have even more concerns which transcend the fact that she's a woman and has other intersectional angles that need to be taken into consideration? So that's about it. Thank you so much.
Thank you very much, Aakriti, for sticking to time again and for your presentation. I feel like with these three papers, we've turned a sort of a full circle. Eliana started off talking about the dark sides of international law, if you like, in perpetuating some of these injustices that lie at the roots of conflicts and that fuel conflicts, also at the moment of ending these and transforming these conflicts. And then Daniëlla focused more on the positive roles, facilitative roles of international law in addressing the issue of land reform in peace processes. And then with Aakriti's presentation, we again heard about maybe the unintended consequences of the humanitarian principle of impartiality, which is also enshrined in international law. And of course, I mean, all of these accounts are valid accounts of the role of international law in conflict and peace, post-conflict situations, because international law is not one thing, it is not monolithic. It points at various directions, it sets certain goals in international peace and security, and then some of its practices and rules and discourses hinder these very objectives that international law sets. So I thought this was a very rich panel in terms of presenting different perspectives. Now we will open up the floor for questions from the audience. I saw some exchanges in the chat. I don't know if Eliana wants to maybe reflect on the concept of slow violence. I saw that she's replied.
Yeah, sure. Thank you, Asli, and thank you to Michael for the nice comment and as I said in the chat, I think that slow violence is a very useful concept, and I'm actually using that in my forthcoming book, which is actually the subtitle is Marginalizing Slow and Structural Violence in International Law. So I'm referring to the work of course, of Rob Nixon, and I think that's quite a very powerful kind of critique of what international law is doing in conflict and in transition to peace, and in relation to question of distribution, natural resources, but also ecological impact of warfare. I think he has a nice chapter discussing the legacy of slow violence and in the aftermath of conflict. And I think that was quite very illuminating when I read it, and it really helped me think critically about, international law and what it's doing there. But in relation to this paper in particular, of course, I mean, this is, it's part of the dark story and slow violence of capitalism, of course, and how that extractivist mentality logic is reproduced without really thinking about the root causes, and how these governance instruments are somehow adopting that logic without challenging it. So thank you very much, Michael, for raising that point.
Thank you, Eliana. Some of you joined us a bit late, so let me just remind you how you can ask questions. Feel free to submit your questions in writing via the chat function, or you can just simply raise your virtual or physical hand and unmute yourself and ask your question. While you're thinking, I do have a few questions for the panelists, so if that's okay, I could maybe start off with them. I'll just ask a question for each of you, and then you can pick whichever aspect you want to address. So Eliana, you focused on good governance reforms, the anti-corruption initiatives, etc. Another tool of international actors when it comes to the issue of natural resource governance in conflict, post-conflict settings is power sharing. And it's also being criticized for perpetuating injustices in a different way, not in terms of entrenching the interests of transnational actors, but in terms of entrenching the interests of warring parties. So on one hand, we have these domestic armed actors who are driven by their own self-interest. And then on the other hand, we have transnational or international actors. And in the middle of this, there are local communities. Do you see any positive role for international law in empowering these local communities? To Daniëlla, I mean, you've talked about addressing the various issues related to land in peace agreements and in general in peace processes. And this approach is getting very common these days, addressing the root causes of conflicts in peace agreements. And the list is getting longer and longer. Human rights, constitutional reform, natural resource governance, climate change, land reform, warring parties, and the local communities have a lot to think about and have a lot to compromise over. And these are essentially very fragile processes. Do you think it is realistic or feasible as a policy to turn peace agreements into such important and comprehensive documents that sort of resolve all these issues about the root causes, instead of maybe opening up a longer process of self-determination in which the international actors have more limited roles and where the local communities can have a more meaningful say over these issues? I'm not sure if this is more realistic than addressing these issues in peace agreements, but I just wondered what you think about that. And then a very quick question to Aakriti. I mean, when you were talking about the issue of gendered humanitarian aid, I was thinking about, and then before you mentioned impartiality, I was thinking about humanitarian principles. And they don't mention accountability. They refer to humanity, impartiality, neutrality, independence. But the accountability gap is a significant problem in the humanitarian sector in general. Just last week, the UN Under-Secretary General for Humanitarian Affairs admitted this and called for greater accountability in the humanitarian sector. I was wondering what you think about the lack of accountability as a humanitarian principle, and whether improving accountability in the humanitarian sector in general would be a solution also to the problems that you've addressed. And connected to this, I was wondering which women you had in mind in terms of representation. Are you referring to more international women, or are you referring to local women? Sorry for the long questions. Maybe we can start with Eliana and go through the order of the speakers.
Yes, sure. Thank you, Asli, for the question. Okay, so your question is whether I see any positive role for international law in empowering local communities in the post-conflict stage. I would say, I mean, this. Perhaps I can answer that question by referring, of course, to the regulatory instruments that I discussed during my presentation. So to put it like, perhaps it's a more narrow answer, but the one that I feel more, confident in answering without making grand statements. So, for instance, it's as I mentioned during my presentation, of course, one of the objectives of some of these instruments regulating conflict minerals or conflict resources is, of course, to address corporate abuses and the fact that of course the operation of corporation in conflict settings can have negative impact upon the local communities, and this is part of a broader discourse on, we can say, the business and human rights movement, right, and trying to develop standards to ensure corporate accountability, due diligence, and so on and so forth. And the problem there is that, as others have pointed out, of course, many of these instruments are often driven by, or at least, include corporation as some of the stakeholders involved in the negotiation of this instrument. And there is perhaps there a problem in the sense that while participation of local communities is encouraged, on the other side, there are, of course, some obstacles also there. So what kind of communities do we have in mind? Not all communities have the same power of shaping, the development of those mechanisms. There is definitely a disbalance, and I think also, for instance, think about the Kimberley process on diamonds, right? The development was driven by all this indignation for conflict diamonds, blood diamonds, but then I think Daniëlla, that she studied a lot those mechanisms, she said, one of the driving force behind that was actually the diamond industry, because wanted to protect the legitimate trade against, the fact that armed groups were taking advantage of that. And so you see, in a way, I don't know what international law can do, but I see the local communities perhaps a little bit squeezed between the interest on one side, the corporate and transnational corporate actors involved, and on the other side of the armed groups as well. So I perhaps have a less, romantic view of that. But I think it's impossible to understand what happens there without considering all these different dynamics. And so I'm not sure how much I can answer.
No, thank you so much. This was great. Daniëlla?
Thank you so much. Maybe I can also add a bit to the question about power sharing, because I'm writing a chapter on that precisely at the moment. And I think one of the issues is someone is sharing screen. Yeah, I think one of the issues is, as Eliana raised, with respect to international instruments or mechanisms to curb the trade in conflict resources, one of the things probably that are problematic about them is that they actually entrench elite structures. And that is precisely also what power sharing structures are doing. And so in that sense, they divert attention away indeed from the needs of local communities, although many of these instruments, or in any case, the international mechanisms, do have the interests of local communities at the heart of their objectives, but it's still a problematic issue. Going then to peace agreements, I see your point. So of course there has been a lot of traction for these agreements to address basically everything. At the same time, so maybe two different comments. So first, the reason why management of natural resources should be in those agreements is precisely because we have seen a number of conflicts where this issue was not addressed as part of the peace process, and this has proven very problematic to secure sustainable peace. So that is the reason why these issues need to be addressed in peace agreements. But I agree very much with you that peace agreements are not there to outline the full process. And so what peace agreements must do is, in any case, to provide for procedures, to set in motion particular changes. And in many cases, this is precisely what they do. And so they set up institutions, they set up mechanisms that need to be developed later throughout the peace process. And there, I think the role of local communities is also something that plays a major role in that. And so in that sense, I see peace agreements as part of the process and not as a sort of final solution. And self-determination obviously is key towards making social transformations work in the end. Not to say that international law is particularly helpful in that regard, as we all know. And so in that sense, also maybe to qualify a bit what you said, so what I try to do in my presentation is to look at this general comment as something positive, as something that may help to mainstream international law. But international law itself absolutely has its flaws. So and that's of course an issue that also explains why I feel this general comment is so helpful.
Thank you. And I should clarify, I did mean to mention also that you also addressed the, shortcomings of international law in this area while looking at some of the more facilitative roles of it. But thank you. This is a very convincing take on the role of peace agreements. Aakriti, would you like to go ahead?
Thank you. So back to the second question. And the second question, I remember reading something about it, so that's why I thought I started it. And there's this paper by Elizabeth Olivius who was discussing these two particular case studies on how there were some migrants, Rohingya migrants, who had fled Myanmar and had gone to Bangladesh, and there was some other, I'm forgetting the exact term, but there were some other migrants who basically fled Myanmar and gone to Thailand. And the people in Thailand were the community was a lot more mobilized. They had a lot more, a better voice when it came to addressing or putting forth their own needs before the humanitarian aid workers or say the international organizations for that matter. And in comparison, when you look at Bangladesh, they were a lot more passive, they were a lot more dependent, so much so that they completely started relying upon aid itself and not making an effort to bring forth change from the grassroots level itself. So to the extent that the migrants in Thailand then were concerned, the interesting part about them was that even though they were a lot more vocal about what they wanted, and they had a community, a stronger community when it came to putting forth their needs, and also there were women organizations also very much in place. The international organizations would look at them as a threat. They would not want to take their needs into account and would want to just come up with their own understanding of what they could require. So there was a gap then between what was actually required at the local level and what was actually thought about at the international level, that, okay, probably this is the requirement of the refugees at the ground level. So keeping that in mind, I feel that when it comes to representation, of course, the locals should also have a voice, and that voice should not only be like a suggestion, but that should actually count towards the final decision making when it comes to international organizations. But at the same time, even women at an international level, it should be more diverse when it comes to such panels. So not only locals should have a voice, but also diversity in the panel itself would also go a long way. But again, the diverse panels should also have a sense of sensitization of how the workings are at the ground level. So that needs to be borne in mind. So that addresses the second question. And to the extent that the first question is concerned, and of course, it's a very valid point pertaining to accountability. And yes, humanitarian aid does suffer from it, that there is a lack of accountability to, and some of the concerns that I only raised would be better addressed if there was greater accountability on this front. So there can be accountability not only in context of the refugees or the internally displaced, but they can also be held accountable towards the donors then. But another thing that needs to be borne in mind is that just because we're pursuing accountability and we're making sure that all the needs are addressed of the refugees on that front, it should not result in a space in which all the demands of refugees are taken into consideration and it results in dependency syndrome. So that is a slippery slope that also needs to be borne in mind when you're pursuing accountability. Thank you.
Thank you so much. Do we have any questions from the audience?
I think we do. We have Amanda who wanted to ask a question, I think. Do you want to unmute yourself and go for it?
Yes.
Hi, can you hear me? Okay. I just want to first of all say thank you to everybody for some really interesting presentations. So really thought-provoking. I actually have a question for Danielle. And I'm just interested, as you mentioned, this is draft general comment at the moment, and something that I think is very welcome. It's been on the table for a long time, but I just wondered if there's anything you think is missing from the general comment as it stands at the moment. In particular, you know, I'm thinking myself that I would like to see something around the obligations, or I should say the responsibility of non-state actors, given their primacy in land-related violations, and also the role of non-state actors, say in Colombia, over control of land and the drugs trade, or the role of businesses in land grabbing in conflict. So that's something that I found surprising isn't in the draft. So I just wondered if there was anything else and what your views on that were. And I just wanted to pick up as well on Asli's point about peace agreements, and that, you know, I think as you rightly said, Danielle, peace agreements, we already have, you know, we tend to say peace agreements and clump everything together, but, you know, we already have a process with peace agreements, don't we? We have, you know, cessation of hostilities, where we tend to get broad brush provisions and principles, and then we have interim agreements, and then we have final agreements. So I think, you know, we do have that process already where we differentiate and we get more detail. But I think it's really important that we don't say, oh, actually, we're asking too much and we shouldn't put these issues, whether it be environmental issues or economic, social, cultural rights issues, into peace agreements, because we've seen what happens when that's the case. They get marginalized, they get omitted, they get forgotten. And, you know, if we don't deal with some of those difficult structural issues in the beginning, then again, we can see what happens further down the line when things are left and they don't get resolved, and they just get pushed further and further, and they stay as grievances. So I think it's really important that we don't ignore them or actually think, oh, we're taking on too much, because, and we've seen that in transitional justice as well, where they said, oh, we can't deal with environmental issues, we can't deal with economic, social rights in transitional justice because it's too much, it's overload. And the other thing I think, you know, and I'd be interested again in everybody's views on this is, you know, if we were to say environmental issues and land use and these kinds of issues are pushed further down the line, are we allowing a chance for corporate capture in a post-conflict situation? I think, you know, that's come out very strongly in Eliana's presentation about extractive industries, you know, the role of corporations, and I think we have to be very aware of corporate capture. So that's it, I've waffled. Thank you.
Thank you, Amanda. Sorry, before you answer, I'll just remind you all about the time. We've started a bit late, so we can, I think, go on for another 10 minutes, if that's okay with everyone. But I would really appreciate it if you can try to keep your answers brief. Sorry about that.
Yeah, no, I will do my best. So I will leave out the second part, which I fully subscribe to. It's important to actually include these kinds of issues in peace agreements, because otherwise there's a risk that they get lost down the road. So focusing on the general comment and what is missing, yeah, I see it typically as what the committee has done was really focusing on the obligations, of course, of states. And in that sense, it does refer quite a lot to corporations, which I think is important. But indeed, there is not much mention of other non-state actors such as armed groups. And this is, I think, an issue throughout. Also, I've been involved in the ILC study on protection of the environment in relation to armed conflict. And there also, I think, a very good point of those is that they say, well, parties to an armed conflict have particular obligations also in the aftermath. So their non-state actors are actually addressed. But at the same time, when it comes to issues of responsibility, yeah, it turned out to be too difficult. And I think this is a similar issue with this general comment. So if those non-state actors, if armed groups were to be addressed, it would only be in relation to state obligations. I think this is, of course, yeah, a structural deficiency in the international legal system. But as far as other things, I have to admit that I have to study the general comment a bit more in detail to see what I'm actually missing. Yeah, but very good question.
Thanks.
I think we had a question from Gigi after that.
Happy to waive the fair of questions.
Do we have any other questions? Joanna, please go ahead.
Thank you. Good morning. No, I've been working on this project about international cooperation in Colombia and the role of international donors in the implementation of the peace agreement. So my question is, because we are talking in general about international law, my question is about the role of donors in this regard, because what is happening right now is like the peace agreement, of course, introduced some questions about land, maybe not the best angle, because it was a hard negotiation, and at the end, you know, like private law or private property was the framework within which the peace agreement was negotiated, and in a way, it neglected other ways of understanding land issues in the country, like collective and territorial rights, and well, there are questions that were left out because of the difficulty of negotiating the land issue. Anyway, the thing is that at the beginning, there was like during the previous government, there were a lot of initiatives aimed at strengthening communitarian, let's say, arrangements about land. And there were something called here peace and reserve zones, which were like sort of like territorial divisions, which were created as a way of strengthening self-determination by peasant communities. But with the new government, basically that was left behind. So these initiatives, I mean, they are on paper, you can see they already exist, but the main, or let's say the engine behind this reserve zones was international donations. But because of the new government approach to the peace agreement and the way they have been negotiating donations with international, the big donors, the UN, the European Union, USAID, basically at the moment, those initiatives don't have any sort of financial support. So basically, you know, the way in which now, the thing is that although the peace agreement mentioned this, and there is international law about, like on paper at least, saying this sort of initiative should be strengthened. On the other hand, I mean, without the money, that's almost impossible. So my question is, how do you see the role of international donors and international development cooperation in the context of, on the one hand, the implementation of peace agreements, and in particular regarding land issues?
Yeah, so that's sorry.
No, sorry, I was just going to add, actually exactly the same question that I had. It's just that my question was mostly addressed to Aakriti, because maybe that's the area I knew the least about, but maybe just to extend it. Also, what would be the role of donors in terms of determining to what are the gendered aspects of humanitarian aid and how inclusive it is, and whether you came across it. Yeah, sorry.
Daniëlla, I think you can go ahead, and then we can turn to Aakriti.
Yeah, so that's I mean, it's of course with the implementation of the land parts of the Colombian peace agreement. I think there are a lot of issues. So it's indeed I think it was a very ambitious agreement in the first place, which really looked at well. Creating land rights for the most vulnerable, and then in relation also to with buffer zones and conservation areas. And it's a very, very ambitious agenda in the first place. When it comes to looking at the role of donors, I think, yeah, again, that's of course a difficult issue, and one where I think international law has a serious deficiency, because of course on the one hand, and there is this idea that states are responsible, or in any case have obligations under human rights covenants, not only with respect to their own jurisdiction, but also what is happening. So all these extraterritorial obligations, but on the other, these are not strong when it comes to the financial implications of these kinds of human rights. So I think international law itself, the only thing I can think of is that the push that's in any case human rights bodies are currently trying to accomplish towards strengthening this idea of what I call shared responsibility. So also the obligations of other states with respect to what is happening in for instance, post-conflict states. But this is something I have to admit that I know is simply not well entrenched in international law. So from that perspective, I think there's still a lot to do.
Super. I'm not so sure if I'm correct or not, but I probably did come across this in Elizabeth Lewis's paper itself, and I probably have to go back to it. But of course, it's an area that can be explored a little more, and how, or whether or not there is a connection between the international donors and what's actually happening at the local level, and whether or not their needs are taken into consideration then. And it also stems down to how vocal the local organizations are, and how far they have some sort of a recognition on that front when it comes to putting forth their needs, for that matter. But again, if I'm not mistaken, and if I can recall correctly, there is a gap between the international donors and the local organizations then, and how far the international donors do take into account is there's a paucity when it comes to it. It doesn't completely address what happens at the local level. But I still have to recheck that point. So thank you.
Thank you very much. I think we'll wrap up here. The next session is starting in a couple of minutes. Thank you so much to our presenters for these genuinely fascinating presentations, a lot to think about. And thank you very much for all of you who've joined us, for your questions, contributions. I hope to see you at the other panels.
Thank you, everyone. We hope to be able to continue the conversation,
yes,
also within the context of our project.
Thank you very much.
Thank you.
Bye.
Thank you. Bye-bye.
Bye.
Bye.